Hi, at Denton Peterson we track issues that are important to our franchising clients. One huge issue right now in franchising and employment law is the question of when an employee of a franchisee is considered an employee of the franchisor for purposes of employment law. For example, when does the National McDonald's Organization have the duty to make sure that employees of a McDonald's franchise are treated legally in overtime, vacation pay, and other employment law issues? The answer to that question used to be fairly clear. Generally speaking, franchisors and franchisees were usually considered separate, and local franchisees were the ones who had the responsibility to make sure that employment laws were followed. So if an employee wasn't paid minimum wage or overtime, that would be the franchisee's problem, not the franchisor's problem. But in the past several years, there have been some changes to the law in that area. Overall, there's been a movement toward franchisors having more legal liability for franchisee employees. The question really boils down to control. That is, how much control the franchisee and the franchisor each have over the employee's actions. Just about all franchisors have some kind of input over how employees do work at the franchisee level. A franchisor might say that certain uniforms have to be worn, or certain hours have to be worked, or certain training has to be given, or any number of other things. Every time a franchisor has a requirement like that related to a franchisee's employees, it increases the control. That means it also increases the likelihood that the franchisor could be held liable for employment law violations. As a franchisor particularly, it's important to know how your franchise agreement gives you control over the franchisee's employees, which could then increase the possibility of you being liable if those employees aren't treated right under the law. When a franchisee and franchisor are both liable for legal violations for a particular employee, they are referred to as joint employers. A couple months ago, a court case came down that muddied the waters even more about joint employers in the franchise context. A federal appeals court decided what is the fundamental question in determining whether a franchisor and franchisee are joint employers. That court said the franchisor and franchisee will be joint employers if they, and this is confusing language, but it's directly from the case, they're joint employers if they are not completely disassociated with respect to a worker such that they share, agree to allocate responsibility for, or otherwise co-determine, formally or informally, directly or indirectly, the essential terms and conditions of the worker's employment. Not only is that language really complicated, but it's terribly fuzzy. It doesn't give franchisors or franchisees the ability to take particular, realistic steps that will ensure that the franchisor doesn't get tangled up in the franchisee's employment problems. Plus, the court gave 6 factors that could apply to this analysis. They're complicated and full of legalese, but boiling them down, it's basically 1. Whether the franchisor can direct or supervise the worker. 2. Whether the franchisor can fire the worker or determine work terms. 3. How permanent the relationship is between franchisor and franchisee. 4. Whether the franchisee is commonly owned or controlled by the franchisor. 5. Whether the work location is owned or controlled by the franchisor. And 6. Whether the franchisor is involved in payroll, work comp, equipment, tools, and other things relating to the employment. So as you can see, we have a vague test supported by 6 vague factors. And the court even said that these factors are not exclusive and that a court ruling could be based on any one of these factors or all of them. Frankly, it's kind of a mess for franchisors and franchisees who'd like to plan carefully. So what should franchisors and franchisees do? Well, there are a couple of things. A good first step is to use whatever control you have to make sure that employees get treated fairly under the law. If overtime is owed, pay it. If leave should be granted, grant it. And make sure that whoever's responsible for doing that has good advice from an employment lawyer so it's done right. Beyond that, it makes sense for a franchisor to think, how much control do I really want or need over the franchisee's employees? What employment decisions do I want to be involved in? What employment-related rules need to be in the operated handbook? Versus how much control can I leave to the franchisee? Can I give the franchisee the brand guidance and marketing and other expertise while still leaving control over employees to the franchisee's discretion? Sometimes it's really hard to strike that balance. It's usually a matter of knowing the risk and making intelligent business decisions. That's why it's important to understand how the law applies to your specific situation. At Denton Peterson, when we meet with franchising clients, our goal is to make sure that they can conduct their business with a minimum of legal headaches. You probably didn't go into franchising so that you could worry about legal compliance. So we sit down with clients and come up with careful, realistic plans that let you run your business with an absolute minimum of legal risk.